Welcome once again to Lehto's Law. Here's Steve Lehto.
Just a quick heads up, there will be a commercial at the end of this video. However, this is an important story that the Institute for Justice got involved with, and I have in my hands literally just the opinion written by the U.S. Court of Appeals for the Second Circuit. And so this story is going around right now. It's been reported in the news, and the Institute for Justice has reported it in their own newsletter. And I've had a whole bunch of people send it to me, and people who support the Institute for Justice got updates on this. But this is a civil asset forfeiture case, and this is a perfect example of the kind of case that the average person could not handle on their own, although this woman put up a valiant effort on her own before the IJ got involved. But it's a crazy story. But as of right now, she's still alive as far as her legal situation goes. And this is the kind of thing where at this point, I wouldn't be surprised if they just give her money back. But here's what's happening in the case of U.S. versus Crystal Starling. Crystal Starling is her name. And by the way, one party to the case is $8,040 of U.S. currency. The case caption actually says U.S. versus Crystal Starling, comma, $8,040 in U.S. currency, defendant. So she is listed as a claimant appellant, and the money is listed as a defendant. And that's how they do these things. So the story is that police officers seized just over $8,000 in cash while searching her home as part of a drug trafficking investigation into her then boyfriend. And by the way, her boyfriend's name is never spelled out in here. They actually let him go by initials. So the local police turned over the $8,000 to the U.S. Drug Enforcement Administration, or the DEA as we like to call them, which initiated an administrative forfeiture procedure to claim the money as proceeds from drug sales. Now, acting on her own, she was pro se, as they say, she filed a claim to the assets, forcing the government to terminate its administrative seizure and open a judicial forfeiture proceeding in the U.S. District Court for the Western District of New York. Now, she did fail to timely oppose the ensuing judicial proceeding, and the clerk of the court entered a default against the funds. See, they defaulted the money because the money didn't defend itself properly. So Starling, still acting pro se, sent letters to the district court and the U.S. Attorney's Office seeking leave to file a belated claim to the seized assets. Be aware that the court rules, both federal and most states, say that if you miss a deadline, and you have a good reason as to why you missed the deadline, you can contact them and say, look, I missed the deadline, but here is the reason why I think you should forgive me for being tardy on that. And the court rules allow a court under proper circumstances to say, you know something, you're late, fine, we'll let you go ahead. And I've seen more defaults get set aside by judges because an attorney comes into court and says, Your Honor, my client missed a deadline, here's why, and the judge goes, okay, I'll set it aside. So that happens all the time. The problem here is, no. So she was still acting pro se at this point. The district court held that she had not shown excusable neglect. They denied her an extension of time to file a claim, and they entered a final default judgment against, not her, but against the money. The money lost. You'd think the money would try harder, but no. So the court holds that the district court made a mistake in granting default judgment to the government. Starling's letters are properly viewed as seeking both to lift the entry of default and to be granted leave to file an untimely claim to the assets. So understood, her motion should have been assessed under the more permissive good cause standard, as is any other motion to lift entry of default in a civil suit. So they vacate the grant of the motion to strike and the entry of the default judgment, and they remand for further proceedings. And so here's a little bit more of an explanation, because the court apparently felt it was important just to give that little summary there and say, here's what happened. Okay, and here's how we rule. Go. However, keep this in mind, that more details are, police officers seized just over $8,000 when they searched her home. They were carrying out, the police were, carrying out an investigation into her then boyfriend. So there's no question, it was her home, but she had a boyfriend. The local police came upon that $8,000, which they turned over to the DEA, and the DEA initiated an administrative forfeiture procedure to claim the funds as proceeds from drug sales. What evidence did they have that this was the proceeds of drug sales? Well, they found it in her home, and her boyfriend, they think, may have been doing something bad. So acting on her own, she filed a claim to the assets, which forced the government to then terminate the administrative seizure and move this to court for judicial forfeiture proceedings. As required, the government provided notice of the proceedings on its website and by mail sent directly to her. Now, she claims she didn't see the notice, and after months went by without response to the forfeiture action, the U.S. Attorney's Office moved for entry of default against the money, and the clerk entered the default. Now, the woman, acting on her own, then sent several letters to the district court and the U.S. Attorney's Office seeking leave to file a belated claim to the seized assets. The district court held that she had not shown excusable neglect, denied her an extension of time to file a claim, and entered a default judgment against the seized assets, or the $8,040. On appeal, she argues principally the district court made a mistake by assessing her letters under the strict excusable neglect standard and not the lesser good cause standard, which would be something that she could have reached apparently. So they claim, this is what the government claims, they claim that her boyfriend allegedly sold drugs to an undercover officer or officers as part of a state investigation into trafficking. The police then executed a warrant to search her home on West Main Street in Rochester, New York. I guess it's an apartment, but it gets repeatedly referred to as both her home or her apartment. But they searched her apartment. There they seized currency. They found $7,500 in a top dresser drawer of the master bedroom. And they also found $540 in U.S. currency in the pants pocket of a pair of women's jeans that were laying on the floor in the hallway adjacent to the master bedroom. We can speculate all we want about whose jeans those were. There's a man and a woman involved. Well, maybe we don't have enough facts. Who knows? Also found with the cash were some digital scales and some prescription drugs and also mail addressed to the boyfriend. So apparently the boyfriend, some of his mail was also at this apartment. Now, substantial quantities of drugs were found, allegedly, at a different residence that the government believed was connected to the boyfriend, but not in the apartment that is occupied by the girlfriend, who is, of course, the one who's fighting here to get her money back. So they arrested the boyfriend, and they charged him with state drug possession offenses, and local authorities turned the seized money over to the feds. Acting on her own, she filed a remission petition and an administrative claim against the seized funds, and by operation of law, her claim terminated the administrative forfeiture proceedings and required the government to initiate a judicial forfeiture action in court, which would be the Western District of New York. The U.S. Attorney's Office, the Western District, filed a complaint against the seized funds in April of 21, alleging they were proceeds of the boyfriend's drug trafficking. The complaint acknowledged that the woman was interested in the seizure and had earlier filed a claim with the DEA. Consistent with its obligations under the federal rules of civil procedure, which governs civil forfeiture actions, the government provided notice of the action by posting on the government's forfeiture website for 30 days. And I've joked about this before. A lot of times the court rules will say you can notify somebody by posting it in a public place or posting it in the local newspaper. Who actually visits the federal government's forfeiture website to see what's being forfeited these days? And they, again, by the way, posted it there for 30 days. They also sent by FedEx a notice and copy of the complaint to her, which she says she did not get because she was out of town. And I was a little surprised by this, but apparently the rules here actually say that the government can serve notice to any person who reasonably appears to be a potential claimant by any means reasonably calculated to reach the potential claimant. So if FedEx is reasonably calculated to reach the potential claimant, it's considered good service. And yet summons and complaints must be served a little bit more specifically than that. So that's a concern, but she was out of town, she says, so she didn't see that, and that is one of the things that caused a problem here. In August, having not heard from Starling and no challenge to the forfeiture proceeding being made, the government moved forward and was granted a default. Roughly 3 months later, and before the government's motion for default had been granted, Starling sent the first of 4 undated letters to the U.S. Attorney's Office and the District Court. Still acting on her own, she stated that the West Main Street apartment was her residence and that she was seeking return of the seized funds because it turns out that the boyfriend was acquitted, among other things. So they charged him with some drug-related offense, and he was found not guilty. At this point, the government apparently contacted her and offered to settle the forfeiture action by splitting the money. Give up your fight and let us keep half. And that is a common tactic they do. And here's the weird thing. I've mentioned before the concept of a binary proposition. A binary proposition means that in some situations there are 2 choices, one of which is correct, one of which is incorrect. You cannot have both choices, and you cannot have neither choice, meaning pick one. Okay? So either this money is the proceeds of something nefarious, or it's not. If it's not, she gets it. If it is, she doesn't get it. So when the government says, fine, we'll split it with you, that is the same as Solomon and the baby and the half thing. Okay? It doesn't make any sense. You're going to keep the half that is connected to crime, and I get to keep the half that's not? Where does a half come from? Why not a third? Why not 7/16? So obviously, they just do this because they know the average person, when told, well, you might get 0, do you want 4? Some people will jump on that. So they offered to split it with her, but she rejected the offer. And she declared that she'd like to move forward with court proceedings to have all of the funds returned to me promptly. The government moved to strike her letters as untimely, arguing that because she was given direct notice of this action, referring to the FedEx, that they said that she didn't respond in time. She responded that her untimely claim should be allowed by the district court because she had challenged the prior proceeding, and she contacted and followed the advice of the district attorney presiding over the case that resulted in these monies being confiscated. So she said that she even communicated with the district attorney about this. The government responded with affidavits from 2 assistant district attorneys who handled the prosecution of the boyfriend. One asserted that he had never communicated with her, but the other made the assertion that she did not recall ever communicating with the woman. So she replied by offering a description and documents evidencing 2 conversations she had, and so on. But that's really not the point here. The district court interpreted her first and second letters as a claim to the assets in the judicial proceedings, and the third and fourth letters as an opposition and reply to the government's motion to strike. The district court also considered whether Starling should be permitted to file a claim against the funds nunc pro tunc. It considered this question in terms of excusable neglect and applied that standard and rejected the excuses that she offered because they say that don't reach the right level of standard. So under Rule 55, this court writes, default judgment begins with a motion by a party demonstrating that the non-movement has failed to plead or otherwise defend. Once the motion is granted, the clerk of the court enters a default. After a default's been entered, the movement must apply for entry of a default judgment, which is a final adjudication of the claims, which process may entail fact-finding or hearings by the district court to establish remedies or quantum, that is, to calculate the judgment. Rule 55 sets out alternative standards that a defaulting party must satisfy in order to resist this process. If the missing party appears when the clerk of the court has entered a default but before the judgment's been entered, the district court may set aside the default for a good cause. Turns out that's the rule actually says, for a good cause. But if final judgment has already been entered, the delinquent party must attack the judgment under the exacting standards of Rule 60 by showing, among other things, excusable neglect. Entry of default therefore operates as a final warning before the absent party suffers the hard consequences of a judgment. Because she submitted her letters to the court before final judgment, she asks that her challenge be construed like any other to an entry of default under the permissive good cause standard. The government reads the rules differently. Under Supplemental Rule G5, a party given direct notice of a forfeiture complaint must contest the complaint by filing a claim to the assets before the deadline specified in the direct notice. Because she failed to file a claim within the 32 days specified in the notice, the government argues that she is subject to Federal Rule 6's general principle that when an act may or must be done within a specified time, and the time has expired, the court may extend the deadline only if the party failed to act because of excusable neglect. So this court writes, it does not appear that the government holds itself to the scrupulous punctuality that it demands of a pro se litigant. So they're kind of pointing out that you got to let both sides use the same rules and apply them equally. The question in this appeal is whether the district court was required to use the good cause standard generally applicable to default under federal rules or the excusable neglect standard elsewhere. Ascertaining the appropriate standard by which to assess the letters sent by Starling depends first on identifying the relief her letters sought. And they go through this and explain that she was, in fact, seeking the relief that she should have been seeking. And then it goes on to point out how these things rise to that level. Starling's letters are therefore properly viewed as a dual motion, seeking both to lift the entry of the default and to file a claim against the seized funds. So as the Sixth Circuit recognized when faced with the same question, there are materially different standards in determining whether to excuse noncompliance or to adhere strictly to the rules. And so I can summarize it this way for you. Because of the technicalities of this case, they seize the money. She says it's my money. So it gets turned over to the DEA. The DEA starts an administrative proceeding against the money. The rules say that if she wants to, she can ask that be brought into court, and she wants to litigate it as an interested party because she says, hey, that money is mine. So once she does that, they then send the stuff over to the court, and it's going to be litigated in court. While there, they apparently sent a notice to her by FedEx to her apartment that she didn't get, that she says she didn't get, and she didn't respond in time. So they entered a default. However, she then responded and said, look, set the default aside. I have a good reason why I didn't respond, i.e. I didn't get your FedEx, and I'd like to argue this on the merits. And they're saying, no, you can't do that because you're in default. And once you've been in default, you've got to have this excusable neglect standard, whereas it's just good cause. And her good cause is I was out of town and didn't get the FedEx. So somebody delivers a FedEx to an apartment? Well, that's not a foolproof way of serving somebody. I know the court rules allow it. I'll give you my favorite story involving service. As an attorney, I'm allowed to serve defendants in cases that I've filed. I've actually hand-served somebody myself, walked up to them and said, are you so-and-so? Yes. Boom, you are served. And I've actually had a defendant come into court and say, Your Honor, I was never served. And the judge looks at me and goes, how were they served, counsel? I go, I hand-served him myself. Judge looks at the guy and goes, have you ever met Mr. Lehto before? And how do you get around that? Because I can tell you the day, time, address, who answered the door. And but people will sometimes claim they weren't served. But on the other hand, I've also had people tell me that they sent a FedEx someplace and the people say, I never got the FedEx. And you go look, was there a signature on the FedEx? No signature was required. What happened to the FedEx? It got stuck in somebody's door. Okay, then what? So that's a really, really weird situation. So it sounds to me like she has good cause. And so all that's happened here is the Court of Appeals has overturned the ruling of the lower court. The default is going to get removed. The case is going to be reopened, and she can litigate this. Now, you might say, but Steve, it sounds to me like they're winning here. The feds are winning here because they've run this woman through the ringer. She's had to do all this to get her $8,000 back. Well, the reason she can do that is that the Institute for Justice finally got involved in this. And despite the fact that she was doing a pretty good job on her own, the Institute's got involved and they're helping her on this. So now they take it back down to court. They're going to litigate over the $8,000. And guess what they think of your offer to split the money? And so I've mentioned this before. Civil asset forfeiture is the idea that they take money from somebody and say, well, we think the money was either being used for a crime or was the fruit of a crime or somehow it's connected to crime. Therefore, we can just seize it. And if you want your money back, you've got to sue us and, in essence, prove that your money is innocent. So not only do they take something from you, but they also have flipped the burden of proof in such a way that you have to prove the money is innocent. Proving the money is innocent can be difficult and expensive. And so the government, of course, doesn't have to spend money on legal fees because they've got attorneys sitting around. Just send them in, and you've got to hire an attorney. So let's suppose that you hire an attorney who charges you $10,000 to get your $8,000 back. If you win, you're still down $2,000. And that's assuming you get an attorney to do this for $10,000. So what they do, and by they I mean the government attorneys, is they go, oh, let's just make them run up some monstrous legal fees. And that's why you often see these seizures that are relatively small amounts of money. A couple $1,000, $5,000, $10,000, because all of that is well below the threshold of what an attorney would quote you and say, if I'm going to charge you my full hourly rate, we can't go to court and get this back for $2,000 in attorney fees. We can't get it back for $10,000. And so they know that the average person is going to look at it and go, unless it's a matter of principle, it's not worth pursuing. And as a matter of principle, guess what? Government doesn't care. And so if they seize money from 100 people, how many people fight it? And how many people actually fight it through to the end? So that's one of the reasons I like the Institute for Justice so much, is that they will fight this on principle. And the Institute for Justice, of course, is a nonprofit organization that's supported by the generosity of people who like what they're doing. And they are often in these cases that otherwise no one else could touch for economic reasons. It's a simple math problem. How much money will you spend to get your money back? And so there you go. So this woman now gets her day in court, and she has a very good law firm behind her. So we'll see what happens. The Institute for Justice will update us on this. I assure you they will. And when they do, I will bring you that. So that's the story of Crystal Starling and her $8,000 in U.S. currency, and the United States of America just coming back from the Second Circuit back down to the Western District of New York. And there'll be further matters litigated. We'll see what happens. Questions or comments, put them below. Otherwise, I'll talk to you later. Bye-bye. As mentioned at the front end, I said I was going to have a commercial at the end. And here I'm talking about Factor again. And Factor, I've talked about them before on this channel. And I get offers from all kinds of people asking me to endorse their products. And I always say, you know something? If it sounds like something I might be interested in, send it to me and I'll check it out. And if I like it, I'll endorse it. Well, here I am talking about Factor, and here's why. First of all, in case you don't know, Factor makes meeting your nutritional goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. The team of gourmet chefs at Factor create each meal using only ingredients with integrity to help you feel your best all day long. Factor delivers meals to you, okay? So what happens is you sign up for Factor, and once you sign up, you go to their website, you tell them what kind of meals you want. They've got all kinds of different meal plans you can do. And then they will send these things to you, and you get a big box, and it's all packed appropriately, and it's got cold stuff in there. And the meals are in the box, and you get the meals out of the box. And by the way, while we're talking here, I'm going to run in the corner a clip of me unboxing one of these so you can see what they look like. And then also, they're so easy to make in the corner, I'm also going to show you me making one in real time, okay? So this is the cool thing. You have to understand, I've mentioned before, I'm a kind of busy guy. I like to keep busy, okay? So I'm often doing many things in my life. I'm shooting videos, I'm practicing law, I'm driving around in my car. I'm also writing books and articles. I'm often speaking places. I like to travel. So I'm always doing stuff. And one of the things that suffers in my life is my meals. And by that, I mean that I tend to prioritize certain things. Every day, I do 2 videos. I haven't missed a day of videos in years. So that's a high priority for me, right? I practice law. If I've got a court appearance, I show up. Okay? So I show up in court. That's another priority. And so I have all these things prioritized I'm going to do. Somewhere way down the list is eat lunch or eat dinner. And I will admit, it's half laziness and half I don't have the time. Where I find myself eating, generally speaking, periodically bad meals or last minute type meals. And when I do eat, I don't spend a lot of time preparing the food because to me, I have more important things to do with my time. So when somebody comes along and says, Steve, tell you what, we'll make the meals for you. They're good meals. You will enjoy these meals. And they're good for you. And by the way, the meals are simple to make because the meal comes in a package. You pull the cardboard out, you poke holes in the plastic, you stick it in a microwave oven for 2 minutes. You hit 2 minutes, and 2 minutes later, you're pulling it out, and it's cooked. You don't need to read the instructions beyond the first time you read the instructions. 2 minutes. Boom, there you go. And these are good meals, okay? So I will tell you that quite often I'm like, oh, I need to eat something quick. I slap together a sandwich or something, or I often grab frozen food. And don't get me wrong, I mean, I've been doing it for a long time, and the frozen stuff keeps forever, but it's not that good tasting. The Factor stuff tastes good. And that's the real important thing here. So keep in mind that they've got professionals putting these meals together, not just to have them taste good, but to have them be good for you. And so, for instance, I had a couple different chicken meals earlier this week. And, it's like herb roasted chicken, but then it's also got like broccoli or cauliflower or something else with it. And vegetables are one of those things I will tell you right now, regardless of what I'm eating. The vegetables are often the things that are not in my meals because I'm eating a sandwich really fast. I don't have time to wash and cook and, steam the vegetables. So the last time I prepared vegetables for myself that I actually went to the store and bought them and cleaned them and cut them and cooked, it's been a while. It's been a while. However, when I'm doing the Factor meals, I'm eating my vegetables. So ready to eat in 2 minutes. And so, if you go to the office, you have a refrigerator there, bring it into the office, throw it in the fridge. Lunchtime, you walk out there, pull it out of the package, boom, boom, 2 minutes in the microwave, and you're eating. It's insane. I've actually found on days I'm eating the Factor meals, I'm actually saving time, and I'm eating a better meal than I normally would. So I'm in love with these people. It's almost like somebody was up there thinking, Steve Lehto, what does he need? He needs a meal solution. And I'm telling you right now, the meals are good. I've gotten emails and letters from people, and I've said, by the way, if you ever buy something or use something that I endorsed, give me feedback. I want to hear from it. I want to hear from people. Make sure that I'm not just out of my mind on this stuff. And I've gotten comments from people who say, Steve, I've tried it and I like it and I agree with you. And I had a guy send me a note, and it's somebody I've corresponded with before, so I know a little bit about what he does. And he goes, Steve, I suspect that your lifestyle and my lifestyle parallel each other quite a bit. He goes, because I'm busy all day long, and I often either eat a bad lunch or I skip it, or I just snack or something until I get home or whatever. And so he goes, I tried Factor, and I found that it's just such a great solution. It solves the two problems. One is it puts a good meal in front of me I wouldn't have otherwise. And it does it with such efficiency that you can't get over the fact that you can cook the meal in 2 minutes and eat it, and it's good. It's good. That's one of the things I've always been bothered by the people out there who put together the recipes. And they talk about, get these ingredients, go to the store, buy all these ingredients, and you bring them all back, and you start following the instructions. And somewhere along the line it goes, cook this for 20 minutes at 350 or longer, depending on what type of oven you've got. And then you pull it out 20 minutes later and you're going, okay, something's not right. Is that because I didn't do this right? Or should I put it back in? There's no instructions here except for 2 minutes, microwave. So 200, go. And then something beeps 2 minutes later and lets you know, hey, your meal is done. So I have to tell you that Factor has saved me time. It's gotten me eating better. And I can't speak highly enough of them. I really can't. So as part of this, I'm going to tell you that if you head to factor75.com, factor75.com, or if you click the link in the description below the video, use the code Lehto's Law 50. Lehto's Law 50, and of course, spell that out correctly. It looks like Lehto's Law, Lehtoslaw, Lehto's Law 50. and you'll get 50% off your first Factor box, which is a case of meals. And the variety is good, but you can go on and pick exactly what they send you. There's a menu. And they also have different meal plans. So they've got like keto and they've got veggie. They've got all these different meal plans. So if you have specific dietary needs, look at what they've got there and pick and choose from what they offer. So it's a great idea, and they execute it really, really well. And so everything, like I said, from keto to veggie to gourmet plus, you can do all of these things. And like I said, the only time I'm eating my vegetables, it seems, is when I'm eating my Factor meals. And so I love Factor. I absolutely love them. The reason I'm talking about them is I tried them, and it worked out better than I expected. Because I thought, well, it's going to be meals and, save some trouble. No. They're good meals. And they save me the time of having to actually prepare this stuff, and I'm eating better than I would if I was feeding myself otherwise. So yeah, if I go to a restaurant and I'm looking at a meal on a restaurant menu and it lists all kinds of stuff, including vegetables, yeah, I get my vegetables then. But I've also driven to a restaurant, probably spent an hour and a half there, spent a ton of money, and then drove back wherever I came from. And you're talking about a big chunk out of your day. I'm talking about literally. You're walking through the kitchen, you go, I'm hungry. Walk over to the fridge, pull one of the meals out, open the box up, poke the holes in the plastic, 2 minutes in the microwave, and about 3 minutes after you had the idea that you need to eat, you're eating. And it's good food. So head to factor75.com or click the link below in the description. Use the code LEHTO'sLaw50. You will get 50% off your first Factor box. Half off. Half off. So that's a great deal. And you will see from the variety of stuff that they offer, it's amazing. Go visit the website. If nothing else, go visit the website and just look at all the different options they offer and ask yourself, when was the last time you ate that variety of food without going to a restaurant? And that right there to me is the thing. So I will admit that in my life, it's partly laziness, but also it's just simply prioritizing. And I've been somebody my entire life where I've got all these things I want to do. And yes, I do eat, but quite often I was putting that down at the bottom of the list of priorities, and I was not eating as well as I should have been. And right now, while eating Factor, I am eating as well as I ought to be. And among other things, like I said, I'm getting my vegetables. But go in to Factor and look at the variety of things they offer and just try it. And again, if you go there, head to factor75.com or click the link below. Use the code LEHTO'sLaw50 and you will get 50% off your first Factor box. Half off. You can't beat that. Questions or comments? Put them below. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. A programmer is someone who solves a problem you didn't know you had in a way you don't understand.